So yes, good morning, ladies and gentlemen. I am Leon Senyange. I'll be moderating this session, but our arbitrator for the session is Miss Pauline Mbaza. I would like to welcome Edo State University and Assuit University to the round of 16 virtual rounds of the Football Law Annual Moot. Ladies and gentlemen, I would like to officially hand you over to Miss Pauline Mbaza for the session.
Thank you very much, Leon. I'd like to welcome you, Assuit and Edo State Universities, to this round of arbitration for the football arbitration moot. And I would like us to strictly keep time because I believe this is supposed to last 1 hour, maximum 30 minutes for both of the teams. So that being said, I would like to call upon the applicants in this case to please state their case. I'll be following in. I am just wondering if there is somebody that is keeping time, because I may not be able to accurately keep looking at the time because I want to listen to your submissions perfectly in collaboration with your written submissions. So I'm just wondering. I beg your pardon?
I will do the time for you.
Okay, thank you very much, Leon. That being said and done, without further ado, I'd like to call upon the applicants. Please begin.
All right. Good morning, Ms. Paulina. We first want to say a big thank you, ma'am, for the opportunity to be a part of this competition. We really appreciate and we do not take it for granted. Now, my name is Eka Sominana Aisha, and with me is my learned friend, Koslatoya Usigeme, who are appearing for the applicant, that is the Power Star FC. By way of opening this case, before you today, we respectively request the dismissal and striking out of the claim of Mr. Ned, who happens to be for the respondent, on the grounds of illegality, which was unfair, unlawful, and it does not fully align with the FIFA regulation and the CAS jurisdiction, and as such, it is devoid of its substance and its merits. Now, before this temple of justice, which is embedded on the principle of justice, good conscience, and equity, we have filed our documents that is deposed to by the respondents themselves. The documents therein contain our notice of appeal and as well as the grounds for appeal. Now, the grounds for our appeal, one, the notice of our appeal is that the appellants being that
I think you should move closer to the device that you're using because somehow I almost lost you.
Okay. All right. Can you see me now, ma? Okay. Thank you so much. So I said we filed our notice of appeal as well as our grounds for the appeal. Now, our notice is that the appellants being dissatisfied with the decision contained in the judgment of the FIFA DRC delivered on the 20th of March 2025. Now, our grounds for appeal is as follows. Ground one is on the fact that there is an error of law and fact. Now, the particulars for this error is that the employment agreement that is relied upon by the FIFA DRC was never signed, and it is devoid of illegality. Now, we know the general principle of law under the law of contract that before a contract can be valid and binding, there are 5 vital elements that must be present. Now, those 5 elements are very important and sacrosanct. The first one is an offer, an acceptance, an intention to enter legal relation, capacity or competence of the parties. If those elements are not present, it means that the contract is not valid. And before there's going to be a valid contract, there must be agreement. There's a general Latin maxim consensus ad idem, which means there must be a meeting of the mind, which this contract from the respondent failed to achieve. Now, the second ground for appeal is contained in Article 12. Article 12, which is unsigned, which is the unsigned drafts contract, which is expressly provided the dispute to be resolved, as well as the respondent bypass the jurisdiction clause, which is very vital, and it is unilaterally submitted, and it unilaterally submitted the dispute of FIFA DRC. Now, our third ground is on the fact that the appellant was not duly notified at all of the proceedings before the FIFA DRC due hospitalization of the chief executive officer, that is the CEO, whose personal email was used for official communication. This was never seen, and as well as the fact that the club was therefore unable to file a response or defend itself, as it has no knowledge of the pleading suit. I'll be adumbrating on this ground. We'll filed a 5 issues before this before you. Issue 1, 2, 3 will be taken by myself. Issue 4 and 5 will be taken by my learned friend here. The issue 5 is on issue 1 is on the grounds that whether or not the FIFA Dispute Resolution Chamber, that is the FIFA DRC, had exclusive jurisdiction clause in Article 12 of the contract, which means that the Nigerian DRC has a sole dispute resolution forum. I'll be adumbrating on the first issue. My lord, according to Article 22 sub B of the FIFA regulation on the statute and on the statute of players, which states that without prejudice of the right of any player or club to seek redress before a civil court for employment-related disputes, FIFA is competent to hear employment-related disputes before a club and a player of an international dimension. It is seen from this contract that there was no valid contract between the FIFA DRC as well as the respondent, because they failed to meet this vital part and the ingredients of the elements part of the contract. Also, I would like to draw our mind to Article 22 sub B of the RSTP, which states that the contract or a collective bargaining agreement is applicable to all parties. Now, the Independent National Arbitration Tribunal must guarantee a fair proceeding in respect to this case. Now, the principle of equal representation and players of the club. Also, the appellant aligns first that the FIFA, particularly that of the DRC judge, had no jurisdiction to decide the present case of arbitration. I'd like to
inquire. Hold on, counsel. I would like to ask you, are you within the time frame to appeal this decision of the DRC?
Sorry?
Are you within the time limit to appeal the decision of the DRC?
Yes, ma'am.
Please, could you explain what the time limit is? Just to repeat myself, I would like to ask, are you within the time limit to appeal the decision of the DRC to CAS?
Yes.
And I would like to inquire when the decision of the DRC was given.
Okay, on the 20th of March.
Okay. It's okay, please proceed.
Okay, it was during on the 20th of March, and it will take a stimulated time of about 3 months or so. Okay.
Please proceed.
So thank you, ma'am. So I'll be adumbrating on the second issue as to whether or not there is a valid and a binding contract that existed in the absence of a countersigned copy from the Powerstar FC. Now, it's a general rule that there must be a 5 elements a 5 vital part of contract, which I've already stimulated in our first issue, that is the offer, the acceptance, consideration, intention to enter legal relation, capacity, and the competence of parties. Herein, it is stimulated that the respondent failed to meet this vital ingredient of parties, and it is void ab initio, that is, from the beginning of the contract, it never existed, because they failed to meet this 5 vital parts of a valid contract. Now, for there to be a valid contract, there must be a meeting of the mind. That means there must be a contractual relations between both parties. In this case, it was never seen, and there was no contractual relation. There was no meeting of the mind, consensus at them. It was never seen. They failed to meet this vital part of contract, as well as the fact that there was no meeting of the mind for this part of the contract. It was stimulated in the case of ICLA versus Bright, citation provided, ECLE and BRY80 and PICLOC. It was held therein that where there's no contract and signature is an essential part of this contract, which formulated a valid contract. Also, in Article 8 of the FIFA regulation of the statute and transfer players, the application for registration of professional must be submitted together with a copy of the player contract. Also, I would like to adumbrate on the third issue as to whether net failure to perform the club duty and termination was without the prejudice case. Article 13 of the FIFA RSTP provides that a contract between a professional and a club may only be terminated upon the expiry of the term of the contract or the mutual agreement. Also, Article 17 respectively provided herein, it stated that in addition to the obligation to pay a compensation, that is the sporting sanctions, shall also be imposed on the player round in the breach. My Lord, I would like my second counsel here, that is my learned friend, to adumbrate on the fourth issue and the fifth issue, respectively. Thank you, ma'am.
Okay, so I'll now be adumbrating on issue 4 and issue 5. And issue 4, whether Power Stars FC was denied its rights to fair hearing before the FIFA Dispute Resolution Committee. Now, I'll first rely on the Latin maxim.
I would like to interrupt you, counsel.
All right.
What do you define the term fair hearing as?
Fair hearing, the right to be heard.
So do you believe, from the facts that were given, that the Power FC was not given the right to fair hearing?
Yes, they were not given the right to fair hearing.
Please proceed and explain yourself.
All right. Okay, so I'll first rely on the Latin maxim of audi alteram partem, which means to listen to the other side or let the other side be heard. And the conviction in this trial in which the defendant is not present to answer charges is held to be a violation of natural justice, and a default judgment was made, and the appellant was denied its right to fair hearing before the FIFA DRC, which violates the principle of audi alteram partem, as I already stated. And the default judgment was rendered in absentia, which contravenes the fundamental principle of natural justice as established in the case of CAS 2011/A/2426. This case is a Swiss public policy which requires that parties to an arbitration are guaranteed a fair hearing within a reasonable time by an independent and impartial arbitral tribunal. And it was also affirmed in the Nigerian case of Williams versus Uprising Voluntary Fund Society that where a default judgment is issued without proper notice or jurisdiction.
I would like to ask you, counsel, do you believe before a default hearing is given, the parties are always given a chance to plead their case?
Yes.
Was that the case in Power FC? Was that the case in Power FC? Do you believe Power FC was given the opportunity to plead their case?
Power FC was never given the opportunity to plead their case, and award was already made for them to pay. I'll be adumbrating on issue 5, whether the 40 million awarded by the FIFA DRC was lawful, reasonable, and proportionate. Article 44 of the Swiss Code of Obligation determines that where the person suffering damage consenting to the harmful acts or circumstances attributed to him helped give rise to a compound, the damage, or otherwise exacerbated the position of the party liable for it, the court may reduce the compensation due or even dispense with entirety. The court may also reduce the compensation award in cases in which the damage was caused neither willfully nor by gross negligence, and where payment of such compensation would leave the liable party in financial hardship. I must say that the 40 million that was awarded to the respondent by the DRC does not require that type of money.
Just in your last
Concluding,
minute, just in your
okay,
last minute, I would like to
okay,
ask you, if you are very well familiar with the FIFA procedure rules, the DRC procedure rules. Are you acquainted with them on how the procedure of FIFA DRC would take form?
yes, I am.
And what does it say about the right to fair hearing, like you claim?
It is stated in Article 22B of the FIFA RSTP, which states that every party has a right to fair hearing, and where there is a default judgment, it is contradictory to natural justice.
Okay, thank you very much. Your time has been finished because I asked you in your last minutes of submission. I would like to listen to the respondent's case, and we will proceed from there. Thank you.
May it please the panel. Good morning, Ms. President. Today,
I am not able to hear you, please.
can you hear me?
No.
Now can you hear me, Miss? Now it's better?
Please speak again.
May it please the panel. Good morning.
Would you please speak a bit louder because you're not really that audible? I'm finding it hard to hear you.
Yeah, thanks, Your Honor. May it please the panel. Good morning, Mrs. Arbitrator. Today, we are representing the respondent, Mr. Nitki Komoko, and my name is Ziad Masoud, and my co-counsel Samir Ala. We today represent the respondent. First of all, today we're not about this case, not about Batriel. This case about Blair after months of silence, after months of broken promises and hardship. The Blair was trying to protect his career dignity and trying to be fair to protect the football integrity. Can you hear me, Your Honor? Your Honor, please, can you hear me?
I beg your pardon?
Your Honor, today...
Please proceed. I'm going to listen to you.
We're here today to proceed with procedural issue and substantive issue. I will start with the procedural, and my co-counsel will continue with substantive issue. Can you hear me, Your Honor? Your Honor, please, can you hear me? Yeah. First of all, the applicant requesting for the lack of the maybe the arbitrator leave. Yeah. Can you hear me, Mr. Arbitrator? Mrs. Can you hear me?
Yes, please. I'm very sorry. I had an internet interruption. I'd like to ask you to please kindly repeat your case, just the beginning of it, because I didn't get you.
I'm asking Your Honor to begin our pleading from the first.
You're not audible. You are not audible enough. I can hear you speak, but I can't really get what you're saying.
Yes, Your Honor. First of all, we talk about the procedural issue and the merit issue. I will proceed the procedural issue, and my co-counsel will contain as the last two submission in subsequent issues. First issue, the lack of jurisdiction of FIFA, DCR. The appearance says the FIFA don't have a right to jurisdiction to decision in this case, but it's not an obvious in the case. And also according to Article 22 of the FIFA RCTB, the player from different countries or international regimes had the right to attend to FIFA DRC in international. As you know, Your Honor, the player from Uganda and the club from Nigeria, and this is considered the international dispute, and the FIFA had only jurisdiction to proceed in this case. And also, Your Honor, according to Article 12 of the case, the appearance says the Article 12, the only jurisdiction for NDRC, Nigerian Football Federation, resolution chamber, but is not enforceable. Your Honor, for us and for the player, the Article 12 is not enforceable because the contract is not invalid, is void, is not void, is invaluable, is valid, contract is valid. And how the appearance agreement or proceed about Article 12 it's a true, and how also the contract is not valid. If a contract valid, as all is valid, but is not part or on any point from the contract. And also, furthermore, the article, the Nigerian football dispute resolution chamber is not considered and not recognized from the FIFA DCR as a dispute resolution, according to FIFA Circular 101. Moreover, Your Honor, Article 12 in the case is not legally enforceable because the appealant argument had a counter signed for the contract, and how the contract is not in some point we accepted point and also we refused the points. Please, Your Honor, I will proceed my second submission. Any question on first submission? My second submission is the validity of the contract. The contract is valid and is legally valid according to appealant actions, because the appealant request for the ITS transfer international certificate, and also requesting for the TM and put the player in the system of TMS for the players. And this obvious the contract from action the appealant was asking for. My co-counsel will proceed the last two submissions, Your Honor.
Your Honorable Panel, I am now talk about most important submission and most important facts in this case. I'm gonna talking about arbitration costs and composition and good faith. The player, he did his job in good faith and he played, but the uh, the club breached or broke his promise again and again. So let's talk about composition. Under Article 17, the player has full right for the composition that the DRC or FIFA DRC has imposed on the club, because it's all about unpaid salary and unpaid bonus, and the 40 million naira is also right, because let's conclude it by symbol. And 29 million for 29 months salary, and 20 and 2.9 million naira also for the bonus, that's also on contract, and $500,000 naira also for the repetition, and also 7 billion point 6 for moral damages. And for arbitration costs, it's also about the player has so it's on Article 46.5 in RTSB. The player also has to impose the impose many things on the club, and he has the right for arbitration costs.
Okay, just to interrupt you in your submission, I would like to ask why you believe that the contract is binding. I would like to ask why you believe the contract is binding. Why you believe the contract is binding.
The contract is binding because the club believe, or he raised a dispute about this.
I beg your pardon, I didn't get you. Can you hear me, please?
No, I can't.
Are you able to hear me?
Yeah.
I asked why you believe this contract is binding on Power FC. I didn't get your response properly because your network got a glitch. Have you gotten my question, please? Or should I type it in the text space?
Rebuttal. Or rebuttal. So we ask for reject all club.
Can you see the question in the text space? Okay, please proceed.
Okay. So we ask about reject all the club claims, confirm that the players end the contract with no with a good reason, and give a full compensation that DRC has imposed, and make a club pay all arbitration costs.
Okay, Council, I'd like to confirm if this is the end of your submission.
Please, please repeat, Your Honor.
I don't know if you can hear me. I don't know if your co-counsel can hear me, but I am asking if this is the end of your submission.
Yes, the end of our submission. Yeah.
Okay, thank you very much. I would like to ask the applicants if they have any responses they would like to make to the respondent's case.
Yes.
Please proceed. You have 30 seconds to please state that, and then I will have to give the respondents time to respond to your responses.
Okay. So in the brief of the respondent, they stated that the player is of a foreign nationality, thereby the FIFA NDRC does not apply to them. However, it was stated in the contract that wherever there is a dispute, that it was stated in Article 12 of the contract that wherever there is a dispute among them. Can you hear me?
Pardon?
Sorry?
I beg your pardon.
All right.
Pardon. Yes, I'm just asking.
Sorry? Sorry, I didn't get that.
I was asking you to please repeat your response so that I can get it clearly.
All right, all right. It was stated in the brief of the respondent that the player is of a foreign nationality, therefore the FIFA NDRC rules does not apply to him. And from Article 12 of the contract, it stated that wherever there's a dispute between both parties, the matter will be taken to the FIFA NDRC. When a dispute arises, they took the matter to the FIFA DRC. Therefore, the FIFA DRC lacks jurisdiction. Whether the player is of a foreign nationality or not is not admissible in this matter. Thank you.
Okay.
I would like to ask
Another
the
thing,
respondent. Please let the respondent respond to that, and then they can hear from you again and then respond.
All right.
Your Honor, thanks for your question, and let me respond with our opponent. In Article 22 of the FIFA RCTB, the player from different nationality had the right to jurisdiction in the FIFA DCR. Why this decision is applying for the case or for the player, our player? Our player had his ITC, international transfer certificate, and also playing for Uganda national team is considered the national international player, and also our player considered the Article 12 in the case is unenforceable, and the appellant, the club Power Stars football club, talking about Article 12 about the jurisdiction of the FIFA, and ignored the bonus and payment bonus in the case fact number 4, specifically, Your Honor, and is not a make a sense in how some points in the contract we considered as forcible, as legal, and some points we ignored. This is not way of the fairness of football and the way of the common sense, with all the respect with the appellant and our learned teammates. Thanks, Your Honor.
Okay, thank you very much. I'd like to hear the next response from the appellants.
thank you so much, ma. Can you hear me?
I can hear you.
Thank you. Now, I would like to add the fact on the basics of jurisdiction. Now, when we're talking about jurisdiction, we're talking about the power of the courts to hear a particular case. Now, they are talking about, the respondents are talking about the contract and contract and contract. Now, it is if we want to deliberate on this, if they have the claim, if they have contract, why did the respondent failed on the contractual basics? It is clear that they have no binding contract. Now they are also saying that the respondent had information
And
from
so I would like to ask you why you believe that this contract is not binding on the respondent.
Because there was never a signature. And from the beginning of our case, I stipulated the fact that for there to be a valid
I would
contract,
like to interrupt you and ask you, if the contract was not binding on the respondent, why then did Power FC go ahead into the TMS to register the respondent as their player?
because they consented in affirmative, that is orally, they consented, and then they made effort to follow that contractual basics that, oh yes, they already agreed. I don't know if you get where I'm coming from. They already.
No, I would like to please ask you to clearly state what you're saying so that I can get the point well, because I didn't get that. And my question, just repeat again, why did the appellant go to the TMS system if they had no binding contract with the respondent?
Okay, so the main reason they did that is that there was they already stated it orally. They didn't sign it. Now, for there to be like a valid contract, I already stated the 5 ingredients which must be present. Now they failed to follow that this thing, but they still do not have a signature, which is not admissible. Their signature is not being penned down. They only stated it in affirmative, that's orally. They made it verbal to follow that mutual, but there was not a meeting of the mind. There was no consensus between both the appellant and the respondent. And
thank you very much.
Another thing I would like to add is that this.
I'd like to ask you to please pause a bit so that I request the respondents to please respond to your question.
Thanks, Your Honor. Firstly, I will permit it to address to respond for the learned friends. First of all, the claimant claimed the contract is valid, is void, but contract is actually valid and clear, and how the contract is not binding, and the club paid salary and the player playing the pre-season, and also the club connected in case facts by his CEO to player to come back and play in the next season, and how he paid salary, and how any legal base about discussion and unsatisfied for the player deduction and unsatisfied deduction 50/100 50/100 from his contract. Thanks, Your Honor.
Okay. Okay, thank you very much. And one last response from the appellants. You're muted.
Okay. So another thing I would like to say is on the basics of the fact that now the respondent heard information. I would like to add that part, that if the respondent, they heard information from a source regarding his status, that is in the club, and the respondent did not feel the need to inform the club or even ask about his status in the club. However, he decided to still stay back in his country and arrive late, act for his club duties, which is a basics of irresponsibility. Because I mean, it's a basics for irresponsibility on the fact that you know you're supposed to arrive at your duty post at this particular time. Let's even take this conference room for as an example. Assuming the respondent or maybe the appellant, they arrived at about 10:30. That means they've already missed the session, and it is nobody's fault. Now, these people, that is the respondents, they stayed back.
I would like to ask a question, Council. According to the FIFA RSTP, just to be very direct with this question, according to the FIFA RSTP, don't you think the club has the responsibility to make sure that their player actually gets the visa right on time? Practically, don't you think they have the responsibility to aid the visa process of the player?
Yes. Yes, I would like to answer in positive. They have the right to aid the visa and make sure there is a smooth running of the whole activities, which they did. They did.
Okay. Please wind up what you were saying so that I can have the respondents to make their final submissions or make any responses they would like to give you.
All right.
Thank you, Your Honor. We asking the appellant for how would the contract and how the player late and had a deduction, an unsatisfied deduction for in the player without any legal base, without any meeting before, or any mail or letter sent it with his attorney or his representative, and is not legally. This discussion is not considered about the legal base, and we're asking the appellant to respond. Thanks, Your Honor.
Okay, just to confirm, is this the final submission of the respondent?
Yeah, this is our final submission.
Okay, just one last question, and I would like to ask your co-counsel to please respond to this. I hope he's ready to respond to it. Please affirm to me. Okay, I would like to assume that you've affirmed that you're ready to respond to the question, and I would still like to ask the same question. Why do you believe that the contract is binding on the appellant in this case? Because you have had a constant idea of a contract existing between the respondent and the appellant. And the appellant says that the respondent did that the contract is not binding between the respondent and the appellant. And I would like to ask why you believe that that contract actually binds the appellant. Does
Your
that
Honor,
make sense?
Your Honor, you're asking me or my counsel?
I'll ask the question again. The appellant suggests that the contract is not binding on you, the respondents. So I would like to ask you why you believe the contrary. Why do you believe that the contract is actually binding? Why do you believe that exists a contract between you, the respondents, and the appellants?
Yeah, that's a really good question, Your Honor.
And I would specifically like to hear that response from your co-counsel.
So the answer is, Your Honor, is that the club is paid the monthly salary for the player for net, and also he made an education on it. He gave him a 50,000, not a 1 million, because his absence.
Okay, thank you very much for that response.
Okay.
And I'll delve into feedback about this arbitration session that I've had with you. And this is just on a general note. And besides that, I hope you're aware that I'm not going to give you the verdict for this round. And so that's why I'd like to proceed and just give you the feedback about this session. That being said, I'd like to mention that it is important that you read the moot problem and understand it. After you've read the moot problem and understood it, please go ahead and do research on the relevant laws. In this case, the relevant laws to this particular case, because it involves an international player and a local football club. So you had to acquaint yourself with the FIFA RSTP. Just to be specific, you had to understand what the RSTP Article 23 states and Article 24, Article 22. You had to look at what Article 12, Article 14 BIS states. So you need to understand what the law actually states. You understand? That is just before you actually prepare your submissions. It is oral or written submissions. You need to first understand what the motive is specific that is, and it is given in default, and now Power FC would like to appeal to CAS. The first thing that you needed to understand is what were the laws that are being applied. And like I've already mentioned, the RSTP needed to be applied. Secondly, there is an issue to understand whether you can take this thing to CAS. Yes, they state that Power FC wants to take the issue to CAS. They don't have the arbitration fees, the administration fees. Yes, but what is the jurisdiction? You understand, there are procedure rules, CAS procedure rules, which you need to acquaint yourself with. You understand? So it's not just FIFA regulations that you need to understand, because CAS is going to apply the procedure rules, and they're going to go on and apply the FIFA rules. So you need to understand those and acquaint yourself with them, so that when you come to make a case, you are well grounded in the law and you know what you are talking about. This avoids things like making assumptions just because you believe your common sense is correct. Yes, it is correct, but what do the regulations say? Because we are arguing the law and not ideas that you have in your head. Do you understand what I'm trying to say?
Yeah,
So after you've acquainted yourself with the law, you now have to understand how they apply to which side you are arguing for. If you are the appellant, you need to understand, okay, FIFA does give a procedure for appealing a decision that has been given by the DRC, and so does the CAS. Now you have to understand, if you're an appellant, you have to understand how do these FIFA laws apply and how do the CAS laws apply. And when you understand that, that means you've understood the idea of jurisdiction. That also applies to the respondent, because the respondent needs to understand whether there is actually whether there is actually jurisdiction for the appellant to bring the case against them before CAS. So you need to understand what the law says and understand how it applies if there is going to be an appeal. When you've understood that, you now go back to the facts of the case and how the law was applied to the case. In this case, you need to understand the grounds of the verdict that was given by the FIFA DRC, i.e., like after the DRC has given this is in real life situation, after FIFA has actually given you the outcome of the whole process, they will then give you time to actually apply for the grounds of the verdict. Once you apply for those grounds and they've given them to you, you now need to understand how FIFA actually applied those laws, the FIFA laws, to the case at hand. When you understand that, you now understand why you need to appeal, and then you also, that is on the appellant side, you understand that, okay, FIFA said this and this, but we believe that is not correct because the laws state this, but also apart from the laws, there is case precedent, that is court precedent, which we believe in this case, FIFA made a mistake. This is what I'm trying to say. And when it comes to respondents, you need to show us why you think that the appellants don't have a case and why you think FIFA's judgment was correct. And when you're trying to do that, you need to also understand the laws and case law that comes into play. Ideally, you need to understand, okay, this law was applied because of these reasons, and one of the reasons probably is the facts or how it is in terms of real life situations. But this is a moot problem. But regardless, we are using real life laws to actually argue the moot problem. That being said, you need to also prepare your minds on how to respond to the cases. All rounds are not just about making your submission. All rounds about having to make your case against the other team and be a bit preemptive, or know at least what you expect from them so that you respond to it so that you're able to win. You understand? Because it's not just about stating what was in your moot brief or memorial. It is also about responding to the team that you're facing. Do you understand? So you need to understand that beyond all the things that I've mentioned, you need to know that, okay, we're going to respond to this. So I think the appellants are going to plead that they have jurisdiction to bring this case. So all that kind of stuff. So how do we respond to that? And also, definitely as an arbitrator, this is an all around. I am definitely going to ask you questions, especially drawing from the fact that I've read your moot memorial. So you have to be well versed with what is in your moot memorial, but you must also be ready to respond to questions as fast as possible using the knowledge that you used to write the memorial. Okay, and that applies also to the I'm just giving an example. Even the appellants, you have to be very ready in terms of what is the respondent likely to say. Oh, they may probably say, okay, CAS does not have jurisdiction to listen to this case. So how do we respond to that? And the arbitrator is definitely going to ask us this question, so they expect an answer. So the preemptive part of it is a critical. It's something that applies to both parties, and I would like to argue that you should do these kinds of things moving forward. And besides that, I would like to congratulate you. After giving you all this, I'd like to congratulate you for reaching this level of the all rounds, because not all teams are able to reach this round. So I'd like to congratulate you about that. Also, I would like to congratulate you for being able to put yourself forward and try to make a submission for your cases that you already written. I understand you're going to have a second round for this or something like that, but moving forward, I'd like you to put these things in place. Yes, there is also a need for you, and speaking, I believe in speaking to both teams when I mention all these kinds of things. I'm not specifically pointing to applicants or respondents. You need to be very coherent and eloquent when you're making your speeches, so that there is systematic following of your speeches, so that I don't have to ask something just because maybe I didn't get it, or maybe I'm not hearing you properly, that kind of thing. So you need to put that into consideration. But beyond that, thank you very much for this round. And I'd like to say just that thank you, and I'll let Liam take on from here. Thank you.
Thank you, Sirona.
Yes.
Very super feedback. We learn it from. Yeah, thanks, Sirona.
Thank you very much, all our litigants there and the arbitrator. Very commendable effort, good fighting there from all of you, and from me and the football law and your mood family. We wish you the best in your next endeavors, possibly in the next round. And like the arbitrator has said, the scores will be shared later on after the full round of 16 is completed. Once again, thank you very much, and till we meet again.
Thanks, sir. Yeah, I appreciate it.
Thank you very much.
Thank you very much.